So Jacob Blake, shot 7 times in the back. Were the shootings justified or not? What does the law say? If your hero is Jacob Blake, you're going to be very disappointed. Hello out there. I'm trying to get through.
With his powerful brainwaves cradled in the warmth of reasoning, it's time for Johnny Walker Dredd to straighten you out on a thing or two. Emanating all the way from exciting Las Vegas, Oklahoma, it's the Johnny Walker Dredd Show.
Okay, so Jacob Blake, shot by an officer. They have declined to press charges against the officer. A couple of things that are coming out of this. One is a self-defense claim, and the other one is a claim that they were trying to prevent a felon from escaping. Now, the latter is governed by largely Tennessee versus Garner. It's a Supreme Court decision that came out in 1984 that has largely guided a lot of policies by police officers throughout the country. Plus, we also have to consider state law. Perhaps the state law is a little bit more restrictive. So let's take a look at Tennessee versus Garner. I won't go through all of the events that what happened here, but essentially a young black male that was committing a burglary was trying to flee. He tried to scale a wall. He was not armed. The police officer knew he wasn't armed, and the police officer shot him. The question now becomes, was the officer justified? And Tennessee versus Garner said no. Even though Tennessee law allowed the police officer to open fire if he was preventing a escaping felon, the courts clarified that in this decision. So let's go ahead and go through this. Keep in mind that the term felon has changed over the time. Back in the old days, the term felony was applied to much more serious charges, capital crimes. The Tennessee versus Garner case sort of explored that a little bit. So burglary, in this case here, it was a felony, and they were relying on Tennessee state law that allowed police officers to shoot escaping felons. So let's see here. Let's go on down where it says held. The Tennessee statute is unconstitutional insofar as it authorizes the use of deadly force against, as in this case, an apparently unarmed, non-dangerous, fleeing suspect. Such force may not be used unless necessary to prevent the escape and the officer has probable cause to believe that the suspect poses a significant threat of death or serious physical injury to the officer or others. And that is going to be so important in the Jacob Blake case here, the term or others. Now, keep in mind, this is more restrictive than prior Tennessee law, which basically allowed police officers to open fire just to prevent an escaping felon, whether they were armed, whether they were posing a danger to others or not. It goes on, apprehension by the use of deadly force is a seizure subject to the Fourth Amendment's reasonableness requirement. To determine whether such a seizure is reasonable, the extent of the intrusion on the suspect's rights under that amendment must be balanced against the government's interest in effective law enforcement. So what they're saying is that the suspect has certain rights, the government has certain interests in protecting the community, and there has to be a balance between those two. This balancing process demonstrates that, notwithstanding probable cause to seize a suspect, an officer may not always do so by killing him. The use of deadly force to prevent the escape of all felony suspects, whatever the circumstances, is constitutionally unreasonable. Again, they're saying you can't simply shoot somebody to prevent them from escaping. They have to pose a danger to the officer or to others. Now keep in mind, it says here also to prevent the escape of all felony suspects. If you are in prison and you are in prison for a felony and you escape, this does not apply. I don't know what the law is on that, but I assume that they probably can blast you into kingdom come. The Fourth Amendment, for the purposes of this case, should not be construed in light of the common law rule allowing the use of whatever force is necessary to effect the arrest of a fleeing felon. Changes in the legal and technological context mean that the rule is distorted almost beyond recognition when literally applied. Whereas felonies were formerly capital crimes, few are now, or can be, and many crimes classified as misdemeanors or non-existent at common law are now felonies. So I won't go and read the rest, but they're saying is that when these state laws originally devised, the term felony applied to very serious crimes that were capital crimes. Now that felonies apply to even things that were used to be misdemeanors, it is illogical to apply the term felony in this case. In other words, a person committing a felony has not necessarily committed a capital crime, although in the past that would have been the case. Now keep in mind, this is the Supreme Court's decision that restricts the state's ability to allow officers to shoot fleeing suspects. It could be that a state might have more restrictions on it than allowed by Tennessee versus Garner. So the question now becomes, what is the state law in Wisconsin? Well, if you go into the statutes, you can see here, blow this up, at the bottom, flight on part of one suspected of a felony does not of itself warrant the use of deadly force by an arresting officer. And it is only in certain aggravated circumstances that a police officer may shoot a fleeing suspect. And they cite a case, Clark versus Zidonis. Well, we can look at that. Now, keep in mind, there's nothing in Wisconsin statutes that tell an officer whether he can shoot a fleeing suspect. They're saying basically that the answer to that is found in the common law. In other words, the law as defined by appellate courts through the appeals process. Okay, so in Clark versus Zidonis, it says, flight on the part of one suspected of a crime does not of itself warrant the use of deadly force by an arresting officer. Mr. Zidonis' testimony, however, suggests that he believed that mere flight by one suspected of burglary justified the use of his shotgun. It is only in certain aggravated circumstances that a police officer may shoot the person he is attempting to arrest. Now, it's important to note here that this is, first of all, it's important to note that they're referring to other cases to determine this situation. Okay, let's take a look at these laws. Now, the first case, the first two cases here, this one here is out of Louisiana, and this one, I believe, is out of Mississippi. Okay, so I checked those. This third one here, I conclude that this shooting constitutes the use of unreasonable force under the circumstances. See McCluskey versus Steinhorst. Okay, now if we look at that, we can see that this is a Wisconsin case versus the Supreme Court case. It is dated in 1970, which predates Tennessee versus Garner. So if anything, this is going to be looser than what Tennessee versus Garner stated. Keep in mind that states allowed a lot more freedom of officers to prevent the escapes of suspected felons than determined by Tennessee versus Garner. Okay, so we look under here, under intent. Defendants suggest that the trial court ended in refusing to instruct the jury that an intent to harm or injure is necessary to a finding of use of excessive force in making an arrest. The instruction given by the trial court on this issue is as follows. This question simply inquires with the defendants, who are deputy sheriffs and therefore peace officers, in making the arrest of the plaintiff, used force and violence in excess of that reasonably necessary. A peace officer in making an arrest is justified in using such force as may be reasonably necessary to secure and detain the person arrested to overcome their resistance, if any, to an arrest, prevent his escape, and to protect himself from bodily harm. the peace officer is not justified in using unnecessary force or treating the person arrested with unnecessary violence or wantonly or maliciously abusing the person arrested. So a police officer has a person on the ground, slaps him a few times, the person's already in custody. Police officer cannot use indiscriminate, wanton violence against somebody. However, the officer is not required to determine at his peril the precise amount of force necessary, but it is to be governed and determine the amount of force to be used by what an ordinary, prudent, and reasonably intelligent person would deem necessary were he in the situation of the arresting officer, having the knowledge that the officer possessed and guided by the reasonable appearance and the nature of the case and all of the surrounding facts known to the officer. In other words, you can't use hindsight. An example, a police officer thinks that he has a felon that is escaping and the person is holding a gun, and it turns out to be a BB gun. The BB gun is harmless, but it doesn't matter. What matters is, what did the police officer experience at that time? And under those circumstances, did he have a reason to believe that he was legitimate in opening fire on the suspect? Okay, so what does this mean? Well, first of all, notice that this is a looser interpretation of when an officer can open fire. The Tennessee versus Garner is more restrictive. In this case here, up until Tennessee versus Garner, the state of Wisconsin allowed police officers to open fire as long as they felt that they were preventing an escaped felon, and the amount of force that they used in their minds, given the context of what was taking place, was not excessive. So Tennessee versus Garner is more restrictive, and therefore it is going to hold sway here. And so what does Tennessee versus Garner say again? Let's go back. Held. The Tennessee statute is unconstitutional insofar as it authorizes the use of deadly force against, as in this case, an apparently unarmed, non-dangerous fleeing suspect. Such force may not be used unless necessary to prevent the escape and the officer has probable cause to believe that the suspect poses a significant threat of death or serious physical injury to the officer or others. Since Wisconsin law isn't more restrictive than this, then we can use Tennessee versus Garner to judge the Jacob Blake case. So here are the elements. Okay. 1, was he attempting to flee? Yes. 2, was he armed? Yes. Jacob Blake even admitted that, and that was part of the press conference. But it was pretty clear that if he wasn't armed, he had a knife in the car. They recovered a knife in the car. And therefore, even though he didn't have it in his hand, if he's getting into a car with a knife in it, he's armed. Is he dangerous? Well, guess what? He had already been in a scuffle with police. He basically assaulted the police officers. They tased him. It had no effect. That's dangerous. I'm sorry. If you have a guy who's fighting with police officers and he even shrugs off a taser, he's a dangerous fleeing suspect. In fact, he has committed a felony. Does the officer have a probable cause? Not proof. The officer doesn't have to have proof. And in fact, the Supreme Court decision that the officer does not have to place his own life in peril to determine whether the person poses a danger. And danger to who? A significant threat of death or serious physical injury to the officer or others. Were there others involved? Yes. There were kids in the car. Boom. It's over. That's why they didn't charge him. Well, there's also a self-defense argument. We can look at that as well. But he has committed a felony. They even had a warrant out for his arrest. He has assaulted police officers. They attempted to tase him. He completely shrugged it off. He was armed, and he attempted to flee, in a car filled with kids. There it is. Now, what are the counter arguments? Well, they were his kids. Police officers don't know that. And they don't have to determine that first. They just see kids in the back, armed fleeing felon. It turns out that he didn't even have legal custody of the kids, which, in my opinion, looks like attempted kidnapping, but okay, that's a different story. The rule is very simple. If you're committing a felony and you're armed, you better become unarmed, and you better make it very clear to the police that you are not armed. If you try to flee, you're taking your life in your own hands. Why? Well, in the case of Jacob Blake, suppose they'd allowed him to drive off. Now he's got potential hostages in the car. He's got a knife. He's a felon. And guess what? By not acting, the police officers allowed that to happen. Ultimately, it comes down to this. If you're a police officer and a person has assaulted you, has been completely non-compliant, is armed, and is trying to get into a car filled with kids and drive off, you can't let that happen. It doesn't matter if in the end we look at the evidence and find out, well, it turns out that he was only going to turn on his car radio. It doesn't matter. Again, the police officer does not have to wait to determine whether the threat is real or not. He can take action at that time. He's only liable to what he knows at that time, the context of what he encounters. Would another reasonable person placed in the same situation do the same thing? I have watched a number of videos by police officers, and they say that the shooting was justified. Therefore, in their minds, they would have done the same thing. In my opinion, the reason why Jacob Blake is not going to get justice here is simply because there's nothing that prosecution can do. They're going to lose this. Even if they prosecuted him, even if they win, even if they get a jury to agree, they're going to lose in appeals. There's no point. You're just burning up money for nothing. Where is the problem? The problem is that people don't know the law. Now, keep in mind, I'm not a lawyer. I read and I try to understand as best as I can. Maybe I got this wrong. And if so, and if you are a lawyer, comment below. Point out where I made a mistake. I'm more than happy to look at it. But I don't think I did. Before burning down buildings and torching cars, maybe it'd be a good idea to open up the law and read it. We are a nation of laws. We go by the law. We don't convict people just because we're angry. It doesn't matter whether the Jacob Blake ruling upsets us. Our emotions don't matter. What matters? The law. The law backs these officers. You're screwed if you're the prosecution. They knew it. They looked at the evidence. They had it in front of them, and they weighed it in terms of self-defense laws and Tennessee versus Garner. They were going to get a conviction here. It's not going to happen.